topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. God, I can't believe this is already the 1st of May already. Well, that means the first Thursday of the month. That means Kay Bender-Rimbaum, our long-time expert. They have been with us, I think it's 10, 11 years now, and they just renewed with us for another year. And I got to just say this because we get so many emails and texts from you about this show as well as their show they do in Orlando and Tampa. And listen, Robert is the senior partner of Kay Bender-Rimbaum, and I know he thanks you. We just appreciate your letters, your good wishes. We so are glad that you enjoyed the show so much, and we're just going to keep bringing you shows. And wow, I got to tell you, I'm looking at the calendar for Kay Bender-Rimbaum for May. Oh my gosh, we had to even actually cut it back a little bit for our scroll. Let me welcome our great expert, Robert Kay Bender-Rimbaum. Good afternoon.
And good afternoon, Steve. Hello, everybody. Happy May.
Yeah, right. Happy May already. I can't believe it. I got to tell you, I got your schedule for May. Wow. You got a lot of class courses coming up.
Well, there's lots of things that people need to know.
Wow, amazing. So we're running most of them on the scroll, and then we promised you that we will do this at the first half of the show and the second half because people said that they don't able to tune in right away. So we'll also announce those then. You know, Robert, God, we get so many pieces of mail each week, people writing about your show. But one of the biggest letters we get is people finding your show for the first time. And you've been with us probably like 11, 12 years, but we still get letters, people going, we didn't even know this show existed. So tell people about Kay Bender-Rimbaum.
Well, Kay Bender-Rimbaum, as you've indicated, is a law firm that focuses on community association law, the day-to-day legal needs of condominiums, HOAs, and cooperatives primarily. We do this out of 4 offices. Our main office in Pompano Beach. We have an office in Palm Beach Gardens. We have an office in Orlando, Winter Springs, and in Tampa. And we're available across the state by telephone, by email, as well as certainly happy to visit with most people that we are in the vicinity of. Anything that associations are dealing with on a day-to-day basis, be it reviewing the governing documents to determine rights and responsibilities of the parties and the owners, addressing covenant violations, unpaid assessments, contract negotiation, contract enforcement, dealing with construction defect, major construction defect. We have board certified attorneys from the Florida Bar in all of our offices and community association, as well as one in construction defect litigation. Basically, we are what associations need for their regular legal needs.
You know, Robert, I tell you this every month. We get those sad letters, people who have had their condos for many, many years, and the new laws went into effect. And I totally understand why they needed laws like that. Um, but a lot of people are hurting and they want to know, do you see things getting any better in the future?
Well, things are certainly hope to be better, but it's going to take some time for those many condominiums that have let things go to the back burner when it comes to reserving money for structural issues and long-term maintenance issues. The state has certainly reversed course on the ability for owners to put those off, and has created a new sense of urgency and obligation. There has been a new bill passed, waiting on the governor. It was only yesterday that it was passed, so it remains to be seen at this point if the governor is going to sign it. It is expected that he will. Some of it's going to take effect in July, some of it takes effect in January. It's supposed to ease some of the burdens that had been created previously. I think ultimately, whatever easing is going to be a little bit, not a lot. There's still the requirement that these things be taken care of. But some of the issues that have been raised throughout the state by meetings with various unit owners and public hearings have resulted in some of these changes that have been put in. Can there be more changes? Absolutely. Are some of the changes not helpful? Also, absolutely. There's always drafting issues that create kind of big holes that need to be filled at some point, and more questions than they seem to try to solve. But we'll flesh all that out in the coming weeks. Probably have a better understanding of it all in our next show next month.
Well, we get about, just for your show, and of course, we do the Tampa show each month, which is the last Tuesday of the month. And we also do the Orlando show, which is the last Thursday of the month. We get about, I'd say, about 50 letters from our listeners each month for your show. And we cannot get that many questions on during the show. So we kind of go through them. Some are people asking the same question, so we kind of put those to the side. So what we do is we have a lot of questions that we're going to go through with Robert. We hope one of yours is your question. We also have a chat line next to, if you're watching on YouTube. We know most of you listen on iHeart and Spotify. So we're going to be going through these questions with Robert. Again, I hope one of them was your question. We so appreciate them. Keep sending them. If you want to text it, it's 954-336-3767. And we do appreciate your questions. Let's get to it, Robert. Rex in Delray Beach. At the annual voting meeting for the election of directors, if a quorum is not achieved and the meeting must be adjourned to a later date, is there a window of time that meeting must be set? If nothing is stated in the governing documents, is there a Florida statute that states this?
The answer to the last question is no. The statutes do not provide for the time frame. It's typically going to be in the governing documents, if anywhere. If it's not in the governing document, well, first off, there is no legal obligation to try again unless the documents mandate it, make it a required second effort. If you can't get a quorum, and for HOAs, the quorum's 30% or less, the second time might have the same results, and there's the added expense to the association of having to renotice and put another meeting together. So quite often they don't even try. So It's going to be document specific, and then the board can use its business judgment as to the timing of it. It's generally suggested that it be done relatively soon, but there is no hard and fast rule on that.
Jack in Boca Raton wants to know, can a HOA board vote to change roof style and color without a community vote? 1,000 homes that have the same terracotta color barrel tile roof and now allowing smooth black metal roofs, would that be considered a material alteration since it pertains to the house?
Well, it probably is a material alteration, but that's an issue that only applies to condominiums from a legal perspective. For a homeowner association, the statute does not have any similar provision that limits material alterations within the community, so then you have to deal with whatever your documents provide. And it's fairly unusual for documents to contain material alteration limitation language. Sometimes there may be some relative to capital improvements, putting in things into the community that weren't there before. If you have some green space and the board decides we need another parking area, that's something that would be considered a capital improvement under those documents that might require some vote of the owners. But again, the documents have to be reviewed on that for the limitations if they exist at all. There will be some zoning issues for whatever local requirements exist with either the city or the county of where the property is located that might limit what the board can approve both in materials and color. So the board would need to make sure that whatever they're considering approving is not something that is going to have violations relative to those ordinances. There's likely permit requirements and things of that nature. So that's what they're dealing with in that setting. Now, in condominiums, the statute provides no material alteration except as provided in the documents, usually the declaration of condominium. And if they're silent, then it requires 75% approval of the owners. But since this is an HOA issue, that doesn't apply.
I am surprised we get so many letters about roofs. It seems like that's just such a big subject. It's almost replaced support animals, but we get a lot of questions about roofs.
Well, roofs are eternal.
Yes. Jerry in Boynton Beach, if a board member was on the board last year and has a certification and he was just reelected, have to take the class again, and when must he take it? Does he have to take it in 90 days after the elections? And by the way, K. Bender Rimbaum does offer certification classes.
We do. If it's a continuous service, if he was elected last year and got reelected for this year, then there would not be a requirement for recertification in the subsequent year. If there was a break in his time on the board, then he would need to get certified again. Did he say if this was condo HOA?
He did not. Usually, must be new because all the old ones are all saying whether they're an HOA or condo. He did not say though.
No, the statute provides for extended continuous service, which goes beyond 4 years in most instances. So don't have that issue.
How are people liking the longer classes now?
Well, we haven't heard that much complaint. I know the presenters sometimes get tired, but we do. Sometimes when they're extra long, we split them into two presenters so that they're able to keep it fresh.
Good. Let's go to Jerry in Fort Lauderdale. Can the person who does the reserve study or the inspection also do the repairs? That seems like it's a conflict of interest.
It is a conflict of interest, but not one that would necessarily preclude it from happening. my personal opinion is that it's a better practice to have someone independent who's doing the analysis of what needs to be done from the person who's going to actually be bidding on the work, because then there's no vested interest in having it higher or somehow to that person's benefit. So keeping them separate is better if you can do it. Some of the items in the new statute that was put forth yesterday does provide for certain disclosure requirements for those contractors that might be in that position in advance of doing anything. So at least the statute's considering that as something that at least needs disclosure.
Julie in Palm Beach Gardens, can you remove a present board member before the next election?
Generally, you can remove board members at any time during the course of the year with the caution that you can't bring arbitration actions on a recall within 60 days of the election. So if you try and recall a board member during 60 days before, 60 days after, and they ignore the owner's efforts, the arbitration section will not take jurisdiction of any challenge of the board in doing that. So it's considered kind of like a safe time for board members in those 120 days, 60 before, 60 after. But it certainly, I've seen it done, and if the board member doesn't fight it, then it's effective.
Before we go to your May schedule, I want to ask you a question that we get a lot of letters on, and this is not a board complaint. This is a realtor complaint. We get a lot of letters that people say, what do you do when you find out the realtor that sold you the house wasn't upfront on all the assessment fees and all the fees that were involved?
Well, there are disclosure requirements for most of the community association real estate sales transactions. But if the realtor acted inappropriately, then a complaint to the Board of Realtors relative to that realtor's license would be the appropriate means to address any kind of damage you might get. Otherwise, you'd have to bring legal action against the realtor, him or herself, for what would be considered their fraudulent conduct.
Let's go to your long schedule you've got for this month.
All right. First item on May the 6th at noon, we have covenant enforcement for HOAs and condos, a webinar with Kirsten Hens from the Tampa office, co-presented with GRS Community Management. On May the 7th at noon, association leadership webinar with guests Michael Bender and Jeff Rembaum is hosted by the Castle Group. On May the 13th at 6:30 p.m., legislative session update with Michael Bender. This is a live event in Weston, Florida, hosted by the Bonaventure President's Council, co-sponsored by K. Bender Rembaum and Community Cable Consultants. Michael will be addressing what the legislature has done so far this year. May the 14th, all day, there's a Orlando Condo and HOA Expo, a live event at the Orange County Convention Center. Alan Schwartzside of our Winter Springs office will be presenting Updating Your Governing Documents and the 2025 Legal Update. Updating Your Governing Documents is 9:30 in the morning, and the 2025 Legal Update, which is changes in the law from 24, will be done in the afternoon. On May 20th at 11 a.m., we'll have an HOA board member certification webinar with Kirsten Hens from Tampa, hosted by ACE, which is Association Community Education. May the 20th at 11:30 a.m., we have a live presentation, Lunch and Learn, Covenant Enforceability for HOAs and Condos, taught by Chris Posner from the Pompano Beach office. That will be at Capriccio's Restaurant in Pembroke Pines. Michael Bender will also be in attendance for anybody who wants to meet and speak with him. And then on May 22nd at 8:30 in the morning, another live event, a continental breakfast and education, updating your governing documents with Kirsten Hentz. Unfortunately, I don't have a location of that on this printout, so I will hopefully get that for the second half. That's what I got from me.
Wow, that's a lot. And I got to tell you, I just want to, before we go, we're going to go to break one, but I just wanted to tell Robert, this is a very busy office. You've got, I believe, 4 offices now throughout the state. And I got to tell you that you taking an hour out each month and Alan taking an hour out each month and Kirsten taking an hour, we so appreciate this. We know the listeners and the viewers appreciate it. And that's what you want to educate people, don't you?
Well, it's an area of the law that's complicated and always changing. So you have to keep up in order to protect yourselves.
We're going to go to break. Robert, tell people how they can reach your office.
You can reach us at 800-974-0680, or you can write to us at info@kbrlegal.com, or you can go to the website, kbrlegal.com, and there's a contact screen on the homepage. You can fill that out, and someone will get in touch with you.
We're going to go to a break. We'll be right back with your questions. This is K. Bender Rimbaum. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. I'm here with attorney Robert K. The K. Bender Rimbaum law firm answering your questions. Let's go to Sherry in Boca Raton.
Before we do, Steve, I apologize in that I do have the supplemental information, and in fact, my printout got cut off, and I didn't get all the information out. The last item on May the 22nd at 8:30 a.m. will be at the Seminole Garden Center, and it's presented by K. Bender Rimbaum. There's two other items that I did not have on my items here. Is May 22nd, 11:30 a.m., Navigating the Federal Fair Housing Act, Assistance Animal or Pet. That's a webinar with Danielle Brennan from our Palm Beach Gardens office. It's an oldie and a goodie for you. And on May the 29th at 11 o'clock, a condominium board member certification webinar will be taught by 3 of our attorneys, Andrew Black from Pompano Beach, Ben Hedloff and Peter Mollengarden from the Palm Beach Gardens office, and that's hosted by ACAM Management. So sorry I missed those the first go round.
And we will be announcing those a little bit later in the show.
Yes.
We're going to go to Sherry and Boca Raton. If you are delinquent on your assessments, can you still vote a board member out? And are you allowed to vote for a new member?
Well, unfortunately, the answer to that is it depends. There is the ability of associations to suspend voting rights of people who are delinquent on assessments, but there is a procedure that has to be followed by the association in order for that suspension to take effect, which includes notification to the person being suspended with sufficient time in advance of the meeting that delinquency can be resolved before the meeting occurs. So you have to make sure that the board is following the proper procedures in suspending voting rights if that's going to be effective as to any individual owner.
Kelly, in Boca Raton, we had our elections and a new board member who owns another property management company, and he wants to change many of our vendors. Is that a conflict of interest?
Well, a conflict of interest for a board member is if he's trying to secure business for vendors of which he or she has an ownership interest in, either directly or indirectly. The fact that he's got a management company and may know vendors doesn't necessarily mean he's got a business interest in those other vendors. Just may be companies that he's familiar with their work and thinks they might do better for the community or might work at a better price for the community or whatever reason. But it certainly raises the potential questions. So those questions should be raised as to whether there is any business interest that goes between them, or are they just people that he's sufficiently familiar with by virtue of the work that he does.
Here's Kathy in your backyard, Pompano Beach, in a
Hey, Kathy.
condominium. Do I have the right as an owner to know who has proxies, and can I request a copy of it?
Well, with all of the official records of the association, they are available for the inspection and copying of any owner who submits a proper written request. As technology is evolving and the statutes catch up, likely all of these records are going to be on websites that will be available for downloading, and it'll make the record inspection procedures much more streamlined for those who are sufficiently technologically savvy. But with respect to proxies and election materials, they don't become part of the official records until after the election is over. And so that's the time when they would be available. It's not an appropriate request to say, provide me with copies of something. The request should be, I'd like to have an appointment to inspect these records, and you can make copies with your phone. You can have a portable copy device. If you want the association to make the copies, then you have to pay for them at a reasonable price per page.
We just got a text in from Marcy in Delray Beach, Florida. I love your show. I have probably only missed 2 shows in the last 2 years. Thank you for providing such great information. My question is, they just painted our units and they had to take the hurricane windows off, shutters off. Who is responsible financially for putting the shutters back on?
Well, Marcy, that's something else that could depend on your documents and whether or not that's addressed in there. If it's just painting, typically that's going to be part of the process that the contract provides for, is the removal and reinstallation of the hurricane shutters. Whether or not it's the owner's responsibility to pay for, is again going to depend on your documents. I'd like to give you a better answer or a more complete answer, but I would need the documents to do that.
Here's probably the same answer. Mike in Delray Beach, what if you had a finished wall with tile and they want to break that open? Are you responsible for the finishings? It's probably.
I'm going to assume that's a condominium question. There are provisions in some documents, usually they're older documents, not some of the more current ones, that's called incidental damages. And if that is contained in the documents, it provides that if the association damages portions of the unit while making repairs to the common elements, the association would be responsible for replacing the damages. But the issue that more often than not arises is owners make improvements within their unit and may have very expensive things in there that are now subject to damage when the board has to cut through the wall to get to whatever's inside. Is the association responsible for the upgrades that somebody's put into their unit? And the common answer to that is, unless the documents provide otherwise, the obligation is to pay for putting things back to the way they were as originally created or prepared by the developer. So if somebody has upgraded their unit with very expensive marble flooring, it's not going to be the association obligation to redo all the marble flooring within the unit. An owner puts that in at their risk of the association having to cut through them to get to issues of repair that is the association's obligation. So that is, again, something that is going to be document specific, and you may want to be sure to have some qualified attorney viewing that and providing opinion on it.
Okay, next we're going to go to Michael in Fort Lauderdale. We appreciate you letting us know you are an HOA. He wants to know, we are an HOA, can we see the delinquency reports?
Well, delinquency information is also part of the official records of the association that should be made available to any requesting owner for inspection and copying. And that includes all the information about the delinquent owner, who they are and how much they owe. That's open to the inspection of all the unit owners. Now, what the unit owners do with that information could subject them to some liability, but not the association.
Do the websites for condos, does HOA have the same requirements? Do they have to have a website also?
Substantially similar, yes.
Okay. Alex in Sunrise, he is an HOA. Should we have received a copy of our governing documents with the new statutes?
Well, the governing documents should come from your seller, and the statutes are your own responsibility. That's not something the association is required to provide to you. Condominium associations are required to have within their official records copies of the governing documents that they could provide to any requesting owner, and the owner has to pay for the cost of production of those documents, and they may be giving them electronically, which would have a nominal cost, if any at all. Otherwise, governing documents are something that's available on the public record, and anybody can get those by just simply going to the public record.
Norman in Boca Raton wants to know, if a new director is appointed, is it not active until formally accepted and in the minutes?
Well, for a board member to be appointed by the board to fill a vacancy, that would be a formal act as it occurs, and it's effective immediately. The minutes don't affect the validity of that action. They document it. And so it's important that the minutes reflect it and that it's ultimately adopted by the board at the next meeting that they have, or approved by the board, assuming the rest of the minutes are accurate, the timing of the board members' ascension is not tied to the minutes.
No, in 12 years, Robert, I don't see very many new questions, but here's one for you. This is Jack in Boca Raton. He said, we have 11 people running for the board for 9 spots. There was a tie for 9 and 10. What do we do with the tie?
Well, that's going to depend on if you're a condo or an HOA, does it say?
Yeah, they did not say.
Well, in a condominium, the association has to have a runoff of the 2 people who are tied, and that has to be done within, I believe, 30 days of the date of the election meeting. HOAs, I don't believe the statute has a specific procedure for that. So generally, the first thing we ask is, do either of you want to step aside and allow the other to take the spot? And assuming the answer is no, there are different methods that they can use, but they're fairly informal. You can flip a coin, you can roll dice, you can take numbers out of a hat. You can hold another runoff election, of course, and that's going to take time and cost money. Ideally, that's the way to go, but it's not necessarily mandated by the law.
We just got a text in from Norm in Boca Raton. I am thinking about running for the board for the first time. Any suggestions?
Oh, that's such an open question.
Yeah. Okay.
Certainly let everybody know who you are. You have to be political. You have to talk to people, talk to your neighbors, talk to all the owners. Make yourself sufficiently familiar with the issues that are being addressed by the association. You have to have whatever you have to have for your neighbors and fellow owners to want to vote for you.
Any background they should have, Robert? Any business background?
Well, it's helpful if there is a business background, but a very large percentage of board members do not have a background in this business, and backgrounds in other businesses can be helpful, but this is kind of unique from other business operations. Part of that being, it's not a profit-making venture. The purpose is to maintain property and to assess at the appropriate level to meet your needs, to properly maintain the community in a manner that's going to continue to cause the property values to maintain or increase, as opposed to falling from lack of maintenance. And it isn't the obligation of the business to spend as little as possible so that they can have higher profits. That's obviously not the intent. So general business background is more geared to the profit side than it is to the not-for-profit side, but it does help to have that background because of the issues that you deal with won't be so foreign. Once you're on the board, though, it's important to have sufficient expert assistance in management, in accounting, in legal, if necessary, engineering, depending on your situation, to provide the proper guidance that the board needs. And then you got to do your homework and you have to make decisions.
Robert in Boynton Beach, thank you so much for sharing so much of your legal information with us each month. We really appreciate your show. Can you have too many claims where we would have to worry about our association losing our insurance?
Well, that's a difficult question because different carriers may have different benchmarks that trigger a cancellation. Some, it could be as few as one claim. Some don't even need a claim. But some you can have multiple claims and they'll still provide insurance. So, it really depends on the circumstances that you're dealing with, what type of claims you're making, whether there are claims that you should be making in light of wanting to make sure you don't have the exposure to lose your insurance because you made a claim that was very little over your deductible. You have to make sure your claims are sufficiently substantial that it's beyond what you can afford to address on your own. So it's going to be on a case-by-case basis, but it is something you need to keep in mind given the industry.
Robert, can you go over your schedule again?
I most certainly will.
You've got everything in front of you now.
I'll do the whole thing this time.
Yes.
May the 6th at noon, Covenant Enforcement for HOAs and Condos. It's a webinar with Kirsten Hentz, co-presented with GRS Community Management. May the 7th at noon, Association Leadership Webinar with guests Michael Bender and Jeffrey Rembaum, hosted by the Castle Group. May the 13th at 6:30 p.m. There's a live event, legislative session update with Michael Bender in Weston, Florida, hosted by Bonaventure President's Council, co-sponsored by KBR and Community Cable Consultants. That's going to be at Bonaventure. May the 14th, all day, Orlando Condo and HOA Expo at the Orange County Convention Center. We have a booth, and Alan Schwartzide will be presenting, updating your governing documents, I believe 9:30 in the morning, and the 2025 legal update for those laws that were adopted in 2024. I believe that's at 2:30, but you want to check the schedule on that when you get to the convention center. May the 20th at 11 a.m., HOA Board Member Certification Webinar with Kirsten Hentz from our Tampa office, hosted by Association Community Education, ACE. May 20th at 11:30 a.m., a Lunch and Learn live event, Covenant Enforceability for HOAs and Condos at Capriccio's Restaurant in Pembroke Pines. Chris Posner from our Pompano office will be presenting. Michael Bender will be present as well. On May the 22nd at 8:30 a.m., another live event, a continental breakfast, an education, updating your governing documents, Kirsten Hentz from our Tampa office. It'll be in Tampa at the Seminole Garden Center and presented by KBR. May the 22nd at 11:30 a.m., webinar on navigating the Federal Fair Housing Act, assistance animal or pet. Danielle Brennan from our Palm Beach Gardens office will be presenting. And May 29th at 11 a.m., will be a condominium board member certification webinar. It's got teaching Andrew Black, Ben Hedloff, and Peter Molengarden, and it's hosted by ACAM Management. Go to our website at kbrlegal.com and click on the calendar, and all the events in May will be identified on the days, and you click on the one that you're interested in or the multiple ones you're interested in and register so that you can get the Zoom credentials if it's a webinar, or you can reserve your spot for the live events.
Busy month.
Busy month.
Ray in Boca Raton wants to know, is it true that the corporate transparency document we don't have to fool with anymore?
That is correct as of today. Last we heard was that the requirements of the Corporate Transparency Act were stopped, and it's anticipated that it's going to be repealed, although I have not heard that it has been repealed, but it is not currently the obligation of anybody.
Okay. Eric in Miami wants to know, he said, $70,000 special assessment on our condo. The most of us cannot come up with the money at this time. We cannot borrow the money anymore either. Can we be evicted?
Well, it's conceivable in that if somebody doesn't pay an assessment to the association, the remedy available to the association is file a lien against the unit, foreclose on the lien, and take title to the property. And in doing so, that could result in the eviction of the current owner. I'm not sure why there is the inability to borrow money. I understand 70,000 is a very significant amount, and it would likely not be in the board's best interest to be throwing everybody out who can't pay. If a large number of them can't pay, then you basically have nobody there, and I'm not sure how that would work.
Lance and Boca Raton, a lot of Boca Raton today. They're an HOA, their annual budget meeting. When should advance notice be made? Annual meeting and how much notice? Well, I understand that. You're asking about a budget meeting and the annual meeting, two different meetings.
Well, budget meeting is a meeting of the board at which they consider proposed budget and whether or not to adopt it. And owners are welcome to attend and participate in that meeting. The annual election meeting is a meeting of the membership, all the unit owners, and then they're voting for who's going to be on the board among any other issues that the board presents. The amount of notice will depend on whether you're an HOA or a condo. In a condo, you have to give at least 14 days notice of your budget meeting, and first notice of your annual election is 60 days, and the second notice would happen after 35 days and down to 14 days minimum. HOAs will depend on how your documents are written when it comes to both of those items.
Tracy in Boca Raton, again, another HOA, said, we received notice that we are faced with a special assessment to replace clubhouse and reserves. Is there anything in Florida statutes on how much the amount can go up?
There is not, although in an HOA, reserves are an issue that aren't automatic like they are in condominiums. To have statutorily mandated reserves, that will initially take a vote of the owners to create. And if that was never done in that community, what they're calling reserves are not the statutorily protected reserves, but they would be just a discretionary fund within the overall accounts of the association. An association is obligated under the law to assess for its needs, whatever those needs are. And any limitation statutorily could impede the ability of the association to perform its functions, so there is none. The board has to use its best business judgment in determining what its needs are, and that's got to be based on reasonable documentation and advice of experts that work with the board, so that they're not just assessing crazy numbers that have no basis.
Well, believe it or not, we have come to the end of another show. We had so many more questions. What's that?
This is so much fun. Why do we have to stop?
Well, it's the way you answer the questions. People they love your personality and how. See, imagine if they're your law firm representing your association, how nice it is to work with people like Robert and his other staff.
It is nice to work with us.
How can people reach you, Robert?
You can reach us at 800-974-0680. You can email info@kbrlegal.com or go to the website, kbrlegal.com. There's a contact box on the homepage. And fill out the information, and you'll receive a response very quickly.
Can they reach all of your offices from that number, Robert?
All the offices from that number. Although they all have local numbers, the 800 seems to solve the problem.
Good. Well, you'll be back again with us next month. We so appreciate you. Have a wonderful week, and we'll talk to you soon.
Happy May and happy Memorial Day.
Yes. Thank you. That's attorney Robert Kay of the K. Bender Rimbaum law firm. That's it for us today. Thank you, Juan, our great producer. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.